case briefs, and so much more. LSData's got what you're looking for.
In the case Austin v. Town of Farmington, heard by the U.S. Court of Appeals for the Second Circuit in 2016, the rights of people with disabilities came into focus as it pertained to the Fair Housing Act protections. The critical issue centered on whether or not these protections extended to allow for reasonable modifications to properties, and whether landlords and zoning officials were obligated to permit such modifications unless deemed unreasonable or burdensome. The plaintiff, the Austin family, sought to install a fence, deck, and swimming pool on their property in a patio home area to accommodate their disabled son. Their plans, however, ran into complications when the local town ordinance, which restricted the installation of such structures within the patio home fraction of the site, came into effect. Nevertheless, the town board yielded to the family's need and granted permission to install the intended structures. There was a caveat, a restoration provision, obligating the family to remove the structures within 21 days if certain events transpired. When the Austin family was instructed to remove the structures, they took umbrage, alleging that the directive flew in the face of the Fair Housing Act and subsequently lodged a complaint against the town of Farmington. The district court dismissed the complaint, citing insufficient evidence of discrimination. However, the appeals court disagreed, suggesting the town's failure to allow the modifications to remain beyond their son's presence might constitute a violation under the Fair Housing Act. The court found the family's complaint to lack sufficient evidence of retaliation, but agreed that the case's complexity necessitated further examination into the reasonableness of the required accommodations. This ruling emphasized that such determinations require a full evidentiary record and case-by-case assessments. The appeals court upheld the dismissal of the retaliation claim, but remanded the reasonable accommodation claim for further proceedings, leaving both sides to cover their own legal costs. Thus, the Austin family's quest for reasonable accommodation for their disabled son continues, serving as a reminder of the nuanced challenges families with disabled members often face.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.